May your pleasure, Lordship. I beg to mention a petition for withdrawal. So listing the case,
Day after tomorrow.
Lordship.
My
Yes,
lord,
ma'am.
this is a criminal petition, my lord. It may be listed, my lord, on
When it was
11
last listed,
last listed in 22/3, my lord. After notice, it was not listed.
18th.
May I please, so with the consent of other side, I beg to mention item 27 of today's call list. Can it be posted next week? 27.
After 2 weeks on a day to be taken. Yes,
So another time, item 45. Can it be on Friday, Lordship? Mine. Yeah, what?
these are order matters.
Yes,
Don't you
Lordship,
mention.
yes, Lordship, I have to go, I have some person.
Ask somebody, if we will not pass any order, but thing is, if there is some steps to be taken or something, we'll just
Steps if they can, Lordship, only Friday, Lordship.
45.
Yes, yes.
Okay. Wait for a few minutes. Wait
Yeah.
for a few minutes, pass the order.
Yeah, please, your lordship. My lord, I am praying for listing of a criminal revision petition, my lord, in the next week, my lord, because I am praying interim order, my lord, in this case.
When the matter was last listed,
24/7, my lord. 2 weeks time was granted for filing instruction, my lord. For
28, 20. Right.
May it please your lordship. This case is criminal revision petition. I am appearing for respondent. Respondent, the petitioner obtain interim order very fast day in our absent.
What is your prayer, madam?
I beg, my lord, I beg a mention for listing on in this case on this on
When did you
12
enter appearance for the respondent? When did you file your Okalatnama?
Okalatnama is 2023.
When the matter was last listed?
Last list is 5th October 2023.
Okay, on 16th. 1/6
16.
for audit.
Right,
Yes.
Lordship. Lordship, I would like to mention daily list, Lordship, item 19, Lordship. Matter may be urgent, Lordship, because of Lordship, engaged counsel, like because the out of station, Lordship. Fix any next week, any date, Lordship.
May I please your lordship? With the consent of the other side, I beg to mention item number 17. May the matter be adjourned for today.
You are appearing on whose behalf?
A petitioner.
Have you informed the other side?
Yes, lordship. Lordship, interim is there. It may be continued.
18th. Till then. Okay. Over.
Two steps you have taken, but then kind of.
There is the official dated 5/9/2024. Statement the respondent number 2 was issued on 5/9/2024. Private service. List of 6 weeks. on the date of the paper.
Alright.
I know that. Okay, can you put it? Yes. All the problem.
May I please, Your Lordship? Here in the petitioner, he is the owner of a pond, Your Lordship. Case 11 is the FIR, Your Lordship. Case 11 is the FIR. And the allegation here is that an inquiry was done regarding missing of the cattle which were kept in the pond and Goshala. Case 11, Your Lordship. And after inquiry, it has been found that a large number of cattle have been found missing in the Goshala and pond.
Same report, Ms. Jahan earlier on in one case from this particular case relating to,
That today she is not present, my lord.
no, not required. You have to obtain relating to, if you come to page number 16. Serial number 3. 16. Rastriya Goshala. Got it?
Yes,
Mr. Burwa.
My lord, yes.
With regard to that, there was an application. The report was only for that.
My lord.
So this is with regard to Tonwar Hussain.
that is page 17, Your Lordship, serial number 8, Your Lordship. And during inquiry, Your Lordship, it has been found that there were 24 nongs of cattle, Your Lordship. And out of these, Your Lordship, 17 cattle have suffered death, Your Lordship.
At this stage, my lord, lordship may call for
No,
the case diary.
we'll just, will not call for the case there.
Page 24 and 24 and 26, Your Lordship, may kindly have a look.
Mr. M. Khan, counsel appearing for the petitioner. And Mr. R. J. Burwa, earlier, additional public prosecutor appearing for this case.
17.
Earlier, the investigating officer of Tuksar Police Station case number 84/2023. Registered under section 120B 40637 and IPC. Submitted the report, up-to-date status report relating to Rastriya Goshala Tangna Mari, owned by Ajoy Pal. Also, in similar manner, with regard to say Tuksar PS case number such and such, its investigating officer shall submit up-to-date status report with corresponding to GR number. GR number 293.
Page 24 and 26, Your Lordship, is to. In here, there were altogether 24 nongs of cattle in our pond. And out of these, Your Lordship, 17 cattle have been suffered died, Your Lordship. And remaining 9 nongs of cattle have been handed over to the concerned authority, Your Lordship. That is page 26.
Regard to the pound of POUND of Pulled Short, FULERCH, part 2, owned by Tonwar Hussain. The petitioner hearing. List on 2820.
In the meantime, Your Lordship,
Institute attorney.
I think, Your Lordship, the Ajoypal's case, Your Lordship, on last Friday, it was decided, Your Lordship. So, I
Maybe,
think, Your Lordship, case diary may be in here, Your Lordship. So,
We'll get the up-to-date report. Don't worry. Copy this order to Mr. R. J. Burwa. Fix that.
Publish.
May it please, Your Honor. May it please, my lord. In this case, my lord, it was a case of 13. Informant was not made a party. If the honorable court passes an order, I will take step.
Not required.
Not bigger. My lord, in this case, the trial court convicted the accused person under section 143, 341, 354.
Tell us, there are two concurrent findings. Where is the illegality?
My lord,
There are two concurrent findings, right?
yes, yes, my
To
lord.
interfere with shows the illegality.
My lord. Because there is a grievous injury, question of grievous injury, my lord, there is no medical report at all.
Hmm.
Because there is some evidence that. Though grievous injury, the section 325, but no medical report at all. Even the doctor could not say whether there was any dislocation of any feet, or if it was so, what is the date, age of the injury. Nothing is, doctor has clearly admitted that there is no record, neither any this medical report, nor even his opinion in this regard. So these are these infirmities, my lord, and for that reason, we have come before this honorable court. And the victim and her father has also filed a petition that they have settled the matter at their own level. So matter may be admitted, my lord, and fixed for here.
Justification. You said there was no medical report,
My lord,
no medical report.
no medical. No X-ray report, nothing.
Guru. Mr. Burua, just
My lord.
go through 1 and 2, we have marked, then show it to Mr.
My lord.
Raman. No, no, no. See the pink page you have marked. That's the medical report, but 1 and 2 have written. Show it to Mr. Alam. Sorry, you read it. Then go to the evidence of the PW3 doctor.
My lord, that is because no extra report is there. We are insisting that there is no.
Mr. Alam, that should have been raised in the epic. And go to the PW3, the evidence of the doctor. Mr. Burua, you just read the evidence of the doctor.
Yes, my lord.
Let us see in his cross examination
My lord.
also. First read it from the top.
On 1/6/2012, while I was serving as medical and health officer at Morigaon Civil Hospital on that day at about 11:45 a.m. I am medically examined. I medically examined Sri Sorulora Das, aged about 40 years, male, care of Pramod Das, a resident of village Morakalang under Morigaon PS. And on examination, I found following injury on his person: right upper both incisor teeth lost, right chest wall and back tender type of weapon used, blunt, nature of injury grievous. On the same day and time, I also medically examined one Mukti Das, aged about 14 years, care of Sri Porulora Das, a resident of village Moraklang under Morigaon PS. And on examination, I found the following injury on his person: right side of chest wall and right cheek tender, type of weapon used, blunt, nature of injury simple. Both the above named two injured persons were escorted by Home Guard Mukul Das. Exhibit 2 is the injury report. Exhibit 2(1) is my signature. Cross. There is no X-ray report has attached with case record. The age of injury is also not mentioned in the injury report as submitted by me. So, my lord, this PW1, my lord, he sustained, my lord, grievous injury, my lord, as reflected by the medical report. And PW, my lord, 1, that is a victim, my lord, she sustained, my lord, simple injury.
Yes, Mr. Alam. Tell us. Mr. Alam, kindly tell us.
My lord. Our point is,
These
my
are the
lord,
concurrent findings. There have been laws illegal to have considered. But thing is this, there is an evidence the doctor has examined and found.
because the grievous injury, my lord, must have supported by medical that is
So, because the concerned doctor who examined the victim has already considered that aspect.
and moreover, the parties have submitted affidavit also, my lord, that they have settled the matter.
Where is that?
It is here, my lord.
When they have filed the affidavit?
13th. One minute.
But this is criminal revision petition.
Yeah.
How will you interfere? This is not prorated. You need to have shown an affidavit by the victim. Tell us. Tell us, Mr. Alam.
My lord,
You will tell us only.
because here are some
Wherever there is a compromise, whether it will be
Yeah.
compounded, because this is a criminal revision petition, this is not a criminal petition.
honorable court may take into consideration, my lord.
How can it be?
They,
Under which
if,
provision of law?
they
So
were
as the
in-
authority,
they were in custody, it may be restricted to 10
so as
million.
the authority, that's what we're asking you. Unless you can place something, nothing. All is well settled in this regard.
My lord,
Mr. Alam. There is a concurrent finding. You have not prepared a criminal petition, you have prepared a this thing, a revision petition. What is in the revision petition? You will
yes,
receive a-
354, the first appellate court has removed 354. And the other sections are retained.
Is it compoundable? Tell us. Tell us the law. We'll consider in that circumstances, otherwise. Whether in revision petition, we can consider all these aspects when the concurrent finding is. Up to you. The 54 is not there.
354 is not there.
So
So there is some, this is all one of the circumstances goes in our favor.
that is why we are asking you. It says we are in revision petition, we are not in criminal petition. Otherwise, you'll have no other alternative. So you have placed a copy of the affidavit shown by the informant and the victim. Heard Mr. A. Alam, counsel appearing for the petition. And Mr. R.J. Burwal and additional public prosecution appearing for the state. On 31/05/2012. The victim committed an FIR, written FIR, before the officer in charge of Morigaon Police Station, stating that in the evening around 6 p.m., while she was returning home from the paddy field and was passing by the side of the Mura Kolong Namghar, the accused person, i.e. the petitioner's hearing, obstructed her and wanted to commit rape on her. Full stop. While she made hue and cry, her father arrived at the place of occurrence, and then the accused person assaulted her father as well as her and caused severe physical injuries to their person. For his treatment, the informant stated that her father was in hospital and as such submitted before the authorities of Morigaon Police Station to investigate the matter and to take appropriate action against the accused persons of the case. Pursuant to the same, Morigaon Police Station case number 148/2012 under section 143/341/344/325 APC was registered. Corresponding to GR number 652/2012. After investigating the matter, police on (29/06/2012) submitted the search sheet in said Morigaon PS case number 148/2012, file charge sheet number 55, finding prima facie evidence against the petitioner under section 143 of 341 of 354 of 325 of 323 IPC. Along with this, sir, the concerned investigating officer also placed the medical examination report of the victim by the father of the informant. On 09/08/2012, on Chief Judicial Magistrate Morino, in said DR case number 652 of 2012 arising out of Morino case number frame charge offenses in charge of sections 143, 341, 354 of the IPC, and read over the relevant sections of the IPC and explain those to the accused persons, to which the accused persons pleaded not guilty and claimed to be tried. Accordingly, after recording the evidence of 4 prosecution witnesses, including the informant, the victim, mother of the informant, and the concerned doctor who examined the victim, the learned trial magistrate, by its order dated, by its judgment dated 21/03/2013, convicted the petitioners under section 341 of 354 of 323 of 325 of 143 IPC, and sentenced him for simple imprisonment for 3 months under section 325 IPC, simple imprisonment for 3 months each under section 354 of the IPC, simple imprisonment for 1 month each under section 341 of 323 of 143 IPC, observing the sentences to run concurrently. Again, the same judgment, conviction and sentence passed by London Chief Judicial Magistrate Morigaon in GR case number such and such. The petitioners preferred an appeal. The criminal appeal number 11/2013 under section 370 for service. The London Appellate Court, after hearing the parties by its judgment dated 24/07/2013, passed in said criminal appeal number 11/2013. Partly allowing the said appeal, set aside the judgment of conviction dated 21/03/2013 passed by London Chief Judicial Magistrate Morigaon in their case number 652/2013. Setting aside the punishment imposed under section 354 IPC, upholding the judgment of conviction and sentence dated 21/03/2001 passed by said London CJM Morigaon in their case number pertaining to the sections 143/341/325/3 of the IPC. Agree with the said judgment and order dated 24/07/2013 passed by London Session Judge Morigaon, noted the petitioners preferred this criminal defense under section. Four zero one of 397 of the said. It is contended on behalf of the petitioner that the medical evidence was not exhibited before the London trial court, and without any such medical evidence, London trial magistrate convicted the petitioners under section 30. By judgment, conviction and sentence dated such. It was subsequently upheld in criminal appeal number such and such. On such. It is also submitted by the petitioner that during pendency of the this revision petition, the informant and the victim sworn an affidavit before the notary public at Morigaon on 12/12/2013, stating that the victim, the informant and the victim as well as the petitioner, accused, convicted accused petitioner, have compromised the dispute outside the court. And that the informant and the victim doesn't have any objection if the petitioner are acquitted honorably for relief in said year, case number 652 of the rising of the Morigaon police case numbers. This is the criminal division petition. The order challenge against the concurrent finding by the Royal Minister. By the The medical report of the victim reveals that the victim was examined by the concerned medical officer of Morigaon Civil Hospital around 11:45 a.m. on 01/06/2020. And during such medical examination, the concerned doctor found that incident occurred due to the alleged assault and both the right upper incisor teeth were lost by the victim, with other injuries on his right chest wall as well as on his back, amounting to previous injury caused caused by blunt weapon of the conflict. The said medical report of the victim, father of the informant, was placed at Exhibit 2, and the doctor concerned who examined the victim on 01/06/2000 proved his medical report issued in favor of the victim. However, during cross, the concerned medical doctor who examined the victim admitted the fact X-ray report was not attached with the concerned medical report, and that the age of the injury sustained by the victim was also not mentioned in the injury. However, it is seen that the defense failed to establish or kind of record for the evidence of the prosecution witnesses that the victim did not sustain the injury on alleged assault. The person of the victim by the accused persons of the case class. It is reiterated that this is a criminal evidence taken against the concurrent finding, conviction and sentence caused by the trial as well as the appellate. Finding such materials in the relevant court we did not find, the court did not find any illegality impropriety in the judgment and order of the criminal appeal. Upholding the conviction and sentence that it is caused by the trial. Then it's the judicial magistrate talking about it. 100. I think it's the court. That's being the appointment. The petitioners are directed to surrender the report to the judicial magistrate. Morigo. On or before 18th September 2. The registration communicate this order reported to the Learned petition. Moriga regular. The Learned session that Moriga. Registration portal. Return the case record of GR case number 652 of 2012. Alerting out to Moriga case number to the court of Learned as well as not only the two. No. Okay. Correct.
My lord, one line may perhaps be added. Period in custody, if any. Period in custody, if any, may shall be taken. That line may perhaps be added.
Needless to say. I don't think so because the case there is
354, my lord, 354 non-bailable. Probably they were,
354
if any, my lord.
354 has been set aside. Just a minute. We'll verify for you. Yes, of course. It is seen from the records of the case that the petitioners were arrested by the concerned investigating officer, State Morigaon PS case number on 13/06/2012, and on the same day they were released on personal bond as well as assessment of the local bank after reporting mistake.
Item number 3.
Yes. May please lordship, I'm the petitioner. So my senior engaged counsel is in bereavement, my lord. So he paid if only 1 week's time, or it's 18 or 19 maybe, my lord. Because all of a sudden it has
I
come.
have no objection if the interim order is lifted.
Intimate, my lord,
Absolutely.
otherwise, only 1 week time, my lord, because he is on leave also.
1 year also I have no.
As a last chance, my lord.
The order sheet will reveal conduct.
The case was almost last time I was fixed because of some other case, civil case also there. So on that civil case was tried to settle, ultimately not settle. That is why this case was taken together with the civil case, CRP. Otherwise, my lord, we have not taken time because once one case is settled, that is why this honorable court has taken together. Otherwise, we never took time, my lord.
Where is the protest petition?
My lord, brief is with him, that is the problem. Because all of a sudden he has to go. His auntie is died, my lord. He is in Tezpur.
Okay.
That is the problem. Otherwise, he told me to do the case. Unfortunate, my lord. So we have challenged this, my lord. Actually, so far I understood, my lord. There is the protest petition as well as the order of this landed trial court. This is landed trial court did not call for the CD, original witnesses. This is very important. We have a judgment also. This honorable court. On the basis of that, matter facts and circumstances, stay order granted.
Please submit that counsel for the petitioner, Mr. A.K. Purav. Is under bereavement and is absent by filing letter of absence. Because according reflected in the list again on 23rd.
My 23rd, he will not be here, that is why. My lord, 17, 18, 19, on the next week, we will do the case. We will not further arrange the case.
24th,
25th,
25th,
we'll do the case.
20th.
In the interim order, make content. Much obliged, much obliged. We'll do the case, my lord, because sudden happened. Much obliged.
With your lordship, as per last order, lordship, I have taken instruction. They may be pursuing the matter for settlement, your lordship.
They are pursuing the matter for
Yes.
settlement.
Yes. lordship. So, lordship may fix after puja vacation. In the meantime, if they settle lordship, then I will.
Instruction from the petitioner.
Last letter, my lord. They had sought 1 month time to settle the matter.
Dewar Akrim Ahmed. Miss R. Chaudhary, learned counsel for the petitioner submitted. That both the parties are trying to settle their dispute outside the and they talk of compromise in process. Agreed by the parties, place this matter on 28th of
28 October, lordship.
28th of October.
Lordship, deeply approved.
May I please, your lordship? Your lordship, yesterday this matter was fixed before the court below. We have paid an amount of rupees 15,000, lordship. It is fixed on 22/10 for the date. The difficulty is, lordship, the respondent is not appearing in the court below, lordship. The
Was
last
she
6
available
months,
yesterday?
respondent is not appearing.
Was she available yesterday?
No, lordship, she was not available yesterday. But because there was a direction by this honorable court that interim will be extended subject to the payment of the dues, we have paid an amount of 15,000, lordship.
15 or 50?
15, lord.
What is the area amount to be paid?
Area amount is quite high, lordship, but he is unable to pay because he is working in a petrol pump, lordship. That is why we have made a prayer that 15,000 was somehow, and then she is not appearing for last 6 months, lordship. Continuously she is not appearing. Now 22/10 has been fixed, lordship, in the court below, lordship. And in the meantime, lordship, I will file an affidavit that is on record, lordship. That affidavit is regarding a fact which has come to our knowledge during pendency of this particular criminal division, that she has already contracted a marriage much prior to marrying with me. I have annexed all the documents, lordship.
Those things now in the matter
Yes, absolutely.
cannot be.
This thing has to be looked into by the lower court below.
Mr. Evasati, counsel appearing for the petitioner submitted. That absolute criminal case number 216 of the 2020 was fixed yesterday before the principal Judge Family Court number 3, Kamrup Metro, in which he had deposited rupees 15,000 towards part of area maintenance to his wife and minor son. Good. Mr. Bhattacharya also submitted that next date of site, then that the site abstracting the case 216 is fixed again on 22nd of October. Before the paper. Petitioner is directed to take steps on the
Okay, we have already taken steps, it's required, we have to take a fresh step. Okay.
respondent number. Full respondent,
Sole respondent.
full opposite. To the principal judge. Family court number 3, complaint. Inside applicable case number 216. On the next date fixed, the petitioners shall also place the 11 certified copies of the orders in said abstract criminal case number 216/2000, in which he had deposited a monthly maintenance payable to his wife, sole opposite party, and their minor son. To establish payment, the maintenance he had deposited, maintenance of the wife, children, and the dates on which the large family court release those amounts to the sole opposite party. List on.
Okay, shall we also take steps to raise the post, okay, because the case is fixed on 22nd. Okay.
Petitioner is also direct to, in addition, the family court obtaining necessary acknowledgement. Petitioner is also direct to take steps to 11. The meanwhile, the petitioner shall continue to pay monthly maintenance pay to his wife, commercial list on. 6th of November.
Till then, the interim order may kindly continue. Okay.
If deposit something,
We'll deposit it. Deposit.
will consider at least monthly maintenance.
Lordship, we'll deposit. Deposit.
That's all. What happened, Mr. Arom was there in the morning? You are for the respondent?
How am I?
No representation on behalf of the petitioner. To name of the council that reflected in the council. Or Mr. R. D. Budwal and additional. No, R. D. Budwal and additional for the prosecutor declaring for respondent number 1 and Mr. A. Akum learned counsel for respondent number 2 the complainant. Petition's condition.
Lordship, kindly pass over the method for the time being. Lordship, my senior will appear.
Who is for the education department? Get hold of a secondary education standing council. Get hold of a secondary education standing. Will consider after some.
Obliged, Lord.
May I please the last, madam, that case, my lord, earlier, was gone through that on 8, but then.
Who speaks today?
So I, madam, admission, madam, I think admission, isn't it? Or if the
This is for
admission
best
fees,
for the last item, Lordship fixed the matter for necessary order.
but today is come for admission, ma'am. So in this case, my lordship, twice, my lord, final report was submitted. First, in the first instance, when the final report was submitted, then there was objection by the some informant side. Then again, direction was given by the court below for further investigation. After again, further investigation was made by the IO, and then again, FR was submitted. Ma'am. Then again, he submitted the protest petition, ma'am, and on the basis my complaint was.
Where is that?
Right. But that protest petition is not here, but lordship can go to the first and the order, impugn order, which is at page 44, madam. Page 44, there's an impugn order.
Just a minute.
Protest petition, ma'am, nothing. Now, I have to come in. Public can do it. Copy of the petition filed on page 32.
When the FR was submitted,
My lord,
when the FR was submitted,
first FIR was, my lord,
FR.
yes, FR, my lord. Then I have annexed, my lord, at the page 18, my lord. Oh, no, first FIR is at page 24, my lord. Sorry, my lord.
Okay. Then the magistrate directed for further investigation.
Further investigation, and again,
And the
after
second FR,
second at page 18, my lord. Actually, there was another case against the victim, my lord, where the victim tried to steal some parts of the Bailey Bridge, my lord, and that bridge collapsed on him, and then he died, my lord. And in this regard, on FIR was also submitted by the authorities, my lord, National Highway Authorities, my lord, and he has been succeeded along with another person, my lord, and the case is pending there, my lord. The record has also come, my lord, in this case, my lord, that particular PS case 299/14, my lord. That the theft case, my lord, against the victim and the another accused, my lord. And that justice has
then
not
what
been challenged by the victim side.
after this FR, what happened?
But
Just
second FR,
communicated. Second FR.
that they have filed on protest petition, my lord.
Where is that?
That objection at page, that objection, my lord, at page 32, my lord.
Yes, after this,
Then the court below, my lord, directed on the basis of that, my lord, objection, my lord, to rejected the FR, my lord, and directed to file a complaint case, my lord, register a complaint case, my lord. And then statements of the witnesses are also recorded under 202. Now, my main point is, one in this case, my lord, that what judgment has been also been produced by lordship earlier question, my lord, that Vishnu Kumar Tiwari, man, it is observed in here by the Honorable Appeals Court, but that the court cannot take cognizance on the basis of the protest petition and the witnesses, my lord, examined under 202. The earlier materials that which were collected by the police, my lord, during investigation, on that basis, my lord, cognizance has to be taken. But here, what the MP order reflects, my lord, that cognizance has been taken on the basis of the protest petition as well as the statements recorded under 202 CRS, my lord. So due to this lacuna, my lord, this order itself is not sustainable, my lord, and it should be remanded back at best. My suggestion will be, my lord, because
Mr. Hazarika,
my lord,
you relied on which judgment?
that judgment I have earlier occasion given. Yeah, my lord.
Just give us the citation again.
Where,
There
my
should
lord,
have been normally
lordship has also produced earlier occasion, my lord.
2019.
2019, 8 SCC 27 and para 36 and 44, the relevant portion, my lord.
19 will be 19. It's not 8 SCC 19.
Thought the lordship might go to the para 36. Here also, Apex Court also. My lord.
8 SCC
2019, 8 SC 28, 27.
27.
Party name is Vishnu Kumar Tiwari.
No, Kumar Tiwari.
What to think?
Okay, take the 15.
FIR.
That's okay. That's it.
Mr. Hazarika, take it.
Hello.
Yes, Mr. Hazarika, what do you have to say?
And just what, my lord, that court below, my lord, at least ought to have taken cognizance on the basis of the case diary, my lord, not on the basis of the protest petition and the statements, my lord, taken, my lord, thereafter, my lord. That is what is the judgment of the apex
Whether
court,
the
my lord, has
Honorable Apex Court-
emphasized, my lord. If I'm
Whether the
in para
Apex Court-
30 also, my lord, that is also there, my lord.
Let's see that whether the Apex Court upheld that or it was a decision of the Allahabad High Court.
But that, however, the High Court judgment was relied, my lord, by this.
Allahabad High Court judgment was there. So that's what the Honorable Apex Court found, that it has should have been referred to the larger bench.
Yes.
It did not say that finding of the Allahabad High Court that it has to be considered on the basis of the materials in the case there in the section 190 of the CRTC. The magistrate should take up the matter, right? It is not that it should not be taken up under section 200. That complaint petition, which is the Narazi petition or the protest petition that is submitted by the complainant, should not be acted. The Honorable Allahabad High Court finding was that since the prayer leads to only the setting aside the final decree, right? So, and proceed with the matter. In that circumstances, the magistrate should have considered the materials available in the case
Yes.
and to proceed under section 1. And since that judgment of the Allahabad High Court is available, the other judgment that is not, in that case, would have referred the matter to a larger bench. Whether the Apex Court have given it any finding that in the cases of any such protest petition filed by a complainant or the informant, that should be considered as a complete case under section 200 or it should be considered as a one thing. Is there any finding to that effect?
Let have to look into matter that I have not got it.
There are judgments, I believe.
But this petition was allowed, my lord. Ultimately, that Apex Court, that and set aside by that order of the magistrate, my lord. And I lost in the conclusion, my lord. At best, my lord, my suggestion would be to remand back the matter to and to take the cognizance on the basis of the materials available in the case there, not on the basis of the, my lord, protest petition, my lord, and the statements therefore taken under 202, my lord. That is what this judgment, my lord, reflected from the deflected, my lord. It has relied on different judgments of the other high courts, but also, and that. And apart from that, there is another case also against the victim also, my lord, that both there cannot be contradictory views, my lord, on the same incident, my lord. Charge sheet filed in that case, theft case against the victim and another accused, my lord, where he has been shown as an accused under section 379, my lord.
My lord, this case was filed after 2 months.
But maybe, my lord, because the authorities filed, my
The
lord.
case of murder.
Let me complete my. This case was filed after because the authorities was brought to the notice much later because the authorities taken place in a very remote place, my lord. Later on, when this case was filed, that matter came to the notice of the authorities, my lord. Because it was abandoned bridge, man, it was, my lord. And that charge sheet was not challenged also by the other side, by the victim side, my lord. If they were actually agreed, my lord. Only to, my lord, seal the guilt, my lord, that theft case, my lord, of the accused of the victim, my lord, that this case has been filed, my lord. That this case also filed later on, my lord, after 3 days, my lord, of the authorities, not immediately also. And medical report also, my lord, shows that he has suffered blunt injuries, my lord.
My lord, I'm for informant. I have submitted my written objection, lordship. And the FIR was lodged immediately. Petition one incident was took place on 30/5/2024, and the FIR was lodged on the next date, 31/5/2020. That he was taken to the hospital and he was died there. There was no delay. And the so-called FIR, lordship, relates to the theft, lordship, was filed after 2 months, lordship. And I have annexed the witnesses, lordship, which was taken under section 164, lordship. There are 5 witnesses, lordship, and there is also independent witnesses. They all are, lordship, implicating all the accused petitioners, lordship, in the case, lordship. How they have brutally murdered this person, lordship. they have described, Lordship. And the person who was the deceased person at the time, Lordship, who was found injured, Lordship, he was alive, Lordship, and he himself, Lordship, said the names of that person. And I have also submitted on the last day, Lordship, two judgments, Lordship.
One
2000
that is Sonu Gupta
Sonu Gupta, Lordship,
and
and
Uma Shankar Singh.
Uma Shankar Singh, Lordship. And the order, Lordship, passed by the London Trial Court, Lordship, of order of cognizance, Lordship, after considering complaint petition, entire case record, statement of the complainant under section 200 and statements of the complainant witnesses recorded under 200. Lordship, he has considered all these things, Lordship, and thereafter taken cognizance, Lordship. And at the stage of cognizance, Lordship,
Okay. We pass order.
Ultimately, that order, man, in this case, man, so apex order actually allowed, but the petition was allowed ultimately. Man. Setting aside the order of the man, taking up case. Due to that reason only, man.
Mr. I have to request counsel appearing for the petition. And Mr. Arjun Burwal and additional public prosecutor with the state testimony. Opposite party member. Also, what Mr. M.S. Mazinder, a court support. I have the report petition. Mr. A.M.S. Mazumdar, counsel for the opposite party member. Also, what Mr. Order. Okay, we must do that. Yes, ma'am.
Lordship, I have received the instructions, Your Lordship, and I have given a mail, I think so, whether I don't know whether he has
Communicated.
received it or
Oh,
not.
Section three, instruction.
We brought my lord, that by order it was brought my. So from urgency there, madam, because that's.
But there is a provision of appeal before the secretary, right?
Yes, Your Lordship. This is the instructions of 7/9
No, madam,
of this
this
month, Your
page,
Lordship.
office memorandum, your lordship.
No, because the names are wrongly shown to somebody else, right?
No,
Thereafter,
not
I read-
somebody else, madam. It is stated, your lordship, kindly see, just have a look to page one of that 20. That notification, page 16, page 16. Page 16, man.
Hmm.
Page 16, your lordship will find page 17. Number 3, my lord. Roman 3. The name of the highest level school in which all the other schools are amalgamated shall stand. The highest level school wherever shall be termed as base school. So the name of the highest mine one is high school, and other one is MB school. MB school. And accordingly, your lordship will find that order is there, my lord, page 19, your lord kindly see.
It's 19, sir.
Huh?
24.
24.
24 and
Oh, sorry, madam, 24.
24.
Page 24, I'm sorry. Annex 4, page 24. Page 20. In personal government office memorandum, Summers so and so, my lordship subsequently as per so and so, the following one MB school was so and so, details are given below. Name, your lordship kindly see. So in terms of that notification, then number 2, after amalgamation, mark that the name of the school shall be. About 2, your lordship will say. And this is going on. Suddenly, the director the issue this order, madam. Page 26. Now, next page 26 is the interim order. One 6/22. Plus 2, my dear. Plus 2. Wonderful.
What is the outcome?
Lordship, this is the last instructions.
What
which I
happened?
have
The
received
SMCs
from-
were held. What happened?
There was a speaking order has been passed, Your Lordship, as per the instructions received on 7/9/2024, Your Lordship.
No, that we have seen.
Yes, Your Lordship.
What happened? Because there was a specific direction to hold the SMCs, right?
Yes, Your Lordship.
What happened in the SMCs? That direction was given long back.
I'll need to obtain the instructions regarding this, Your Lordship.
Then
Saturday, Saturday, ito. Na, আমাকে মেল করে পাঠাইছে। আমার পাঠাই।
take a seat, Mr. Chaudhary. Third, Mr. H.R. Chaudhary, Lanet Senior Counsel,
M.A. Chaudhary.
assisted by Mr. Counsel for the petition. Also heard
H. Tarang P. Lordship.
M.S. Freeland, Counsel, Secondary Education for the
Correspondent number 1,
correspondent
2.
number. All the respondents.
All the respondents.
All the respondents number 1 to 30. Anyone for elementary?
Elementary.
Okay. For 1, 2, and 3. And Madam Namtulika,
B. Das. Lordship. Or B. Dekal.
the standing council elementary for the respondents.
4 and 5. Lordship.
तुम्ही काय होईल सर
What?
हां
One.
गवर्नमेंट एजुकेशन
The state government. In the secondary education department, by its office memorandum number ASC 481/2016/164 dated 03/08/2021. Brought into force a scheme, namely within colon Shiksha Kshetra, Ground floor. For amalgamation and merger of different schools. As per the said, one of the clause of the said OM dated 03/08/2021. I लिखा clause 7 within bracket 3 provides that the name of the highest level school in which all other schools are amalgamated shall stand, and the highest level school, comma, hereinafter, comma, shall be termed as base school. Pursuant to the order of the state government in the secondary education department, where letter number ASC .23/2022/75 dated 18/02/2022 and in pursuance to the provisions of the scheme of Shiksha Kshetra under OM dated 03/08/2021. The Director of Secondary Education Assam by order number DSC/GIS Amal amalgamation AMAL / 16/2021/78 dated 29/03/2022 directed for amalgamation of Krishnanagar Rani Gram MV School with the base school Ahmedia High School. And in the said order, the DSC order dated 29/03/2022, the DSC at clause 2 specifically provided that after amalgamation / merger, comma, the name of the school shall be Ahmedia High School. However, by a subsequent order of the state government, subsequent order, the Director of Secondary Education Assam, DSC Assam, however, subsequent the DSC Assam by the order number DSC/GIS/Amal/16/2021/91 dated 01/06/2022 cancel its earlier order under number DSC/GIS/AMAL/16/2021/78 dated 29/03/2022 and issued an order for amalgamation of Krishnanagar Ranigram MV School with the base school Ahmedia High School specifying that after amalgamation of the merger, the name of the school shall be Krishnanagar Ranigram High School. Agreed with the said order of the DSC Assam dated 01/06/2022, whereby after the amalgamation of Krishnanagar Ranigram MB School with Bay School Ahmedia High School, the said amalgamated high school to be renamed as Krishnanagar Ranigram High School. The petitioners filed this writ petition on 08/08/2022. And the court by order, and the court while issuing notice to the respondents by order dated 12/08/2022 in the interim suspended the order of the DSC dated 01/06/2022 under number 30. Renaming the amalgamated school as Krishnanagar Ranigram High School, which is still in.
I'm gonna be photo.
The petitioners herein are the local people resident of Ranigram, comma, Brahman Shashan, BRAHMAN SASHAN, Brahmashan, and Nalua,
And
under the jurisdiction of Karimganj Police Station and Nilambadar Police Station of the state. Karim. According to them, the local people in and around Ahmedia High School.
Clarify one thing, madam. Initially, it was a madrasa.
That's what we're coming back.
That was
That's
provincial.
what we are coming back.
Paragraph 2.
Established. The Ahmedias established a madrasa by name Ahmedia Senior Madrasa at Jalal Nagar Tea Estate. The said Ahmedia Senior Madrasa was provincialized in the year 1994 and pursuant to cabinet decision dated 13/12/2020, Said Ahmadiyya Madrasa, Senior Madrasa was renamed as Ahmadiyya High School
With effect from item 1.21, page 14.
and full stop here. Later, pursuant to the government notification dated 07042021, Said Ahmadiyya Senior Madrasa started functioning as Ahmadiyya High School as per the government guidelines. Pursuant to the government order dated 18/02/2022 and the of OM dated 03/08/2021, Krishnanagar Ranigram MP School was amalgamated with Ahmadiyya High School pursuant to the order of the DSC Assam dated 29th of which, however, was cancelled by the DSC Assam on 1/6/2022, and after amalgamation of Krishnanagar Ranigram MB School with Ahmadiyya High School, renamed the amalgamated high school, said amalgamated Krishnanagar Ranigram MB School and Ahmadiyya High School as Krishnanagar Ranigram. The petitioners in the petition could not establish how they are affected by such renaming of the amalgamated MB school with the amalgamated high school, i.e. Krishnanagar Ranigram MB school with the base school Ahmadiyya High School as Krishnanagar Ranigram High School, as neither their students, neither their children are studying in the said Ahmadiyya High School, nor they are a part of the said Ahmadiyya High School, being in the members of the SMC, the School Managing Committee of the state. On perusal of the Office Memorandum dated 03/08/2021 relating to the scheme for amalgamation and merger of different schools under the state government, the education department, namely Shiksha Kshetra, it can be seen that clause 14 of the said OM dated 03/08/2021 provides that, that's correct, while taking into consideration of amalgamation or merger of schools, the newly converted upper primary schools, high school and higher secondary school from the madrasa institutions, shall have to be taken with equal footing. Further, Clause 15 small b of the said Shiksha Kshetra scheme dated 03/08/2021 of the state government in its secondary education department stipulates that the name of the base school BROS capital to which other schools are merged, shall stand. However, the joint session of all the school managing committees, SMC capital, shall decide the name with the approval of the district level committee, DLC. On perusal of the said scheme of Shiksha Kshetra dated 03/08/2021 of the state government and secondary education department, it can be seen that there is a block level committee both for secondary and elementary sector consisting of the district elementary education officer as its chairman, 2. All block elementary education officers of the district as member, 3. To educationist, all Roman, 2 educationist, preferably one retired principal, public headmaster as member. Member 4. One working principal, P capital, public headmaster, H capital, to be nominated by the inspector of school as member. And B, the district level committee consisting of Roman 1, the additional deputy commissioner in charge education chairman, 2, inspector of schools as member secretary, 3, the district elementary education officer as member, 4, one retired principal of higher secondary or senior secondary school as member, 5, one working principal of higher secondary school or senior secondary school as member, and 6, one working headmaster of high school as member. As per clause 17 of the said scheme of Shiksha Kshetra dated 03/08/2021, such block level committee and the district level committee is required to find out the schools which are eligible for amalgamation of merger in view of the provision of right to education Act of Right and norms laid down by the Sarva Shiksha Vision. From the order dated 010, impugn order dated 01/06/2022. It can be seen or issued by the DSC Assam. It can be seen that it doesn't contain any such recommendation of the district scrutiny committee of district level committee of Karimganj district regarding the change of the amalgamated schools amalgamated pursuant to the order of the DSC dated 29/03/2022 in the joint sessions of the school managing committee, renaming those amalgamated school as Krishnanagar Ranigram High School. Moreover, the scheme of the Shiksha Kshetra, the concerned office memorandum dated 03/08/2021 at clause 19 specifically provides that for any disputes arising out of the order, the aggrieved institution public may appeal before the government in the secondary or elementary education department as the case may be. Following the same, in the order of the DSC dated 29/03/2022, amalgamating Krishnanagar Ranigram MD School with the base school Ahmadiyya High School. At clause 10 specifically provided that in case of any dispute, the said office memorandum of Shiksha Kshetra dated 01/03/20, as well as existing government rule and procedures, etc., shall be followed. Similarly, in the impugn order dated 01/06/2022 issued by the DSC Assam, renaming the amalgamated Krishnanagar Ranigram MP School with Ahmadiyya High School as Krishnanagar Ranigram High School. At clause 10 also provided that in case of any dispute, the office memorandum, the office memorandum relating to the scheme Shiksha Kshetra dated such as well as existing government rules and procedure to be followed. Considering such provisions in the scheme of amalgamation, namely the Shiksha Kshetra, that it's such and such. The petitioner, if so aggrieved, may approach the state government in the secondary education department for, if agree with the order of renaming as September. With the above observation and direction, this petition stands disposed of. In view of the above, the interim order passed earlier on 12/08/2022.
I would like to mention, for application, my lordship, for item number 48, daily list.
Okay.
Okay. 48.
We'll take up before rising, don't worry. Let the admissions be over. Mr. Banerjee, we have considered the judgment that you have cited and everything. And going through the records, we found that two more Caesar witnesses' statements have to be recorded, evidence to be recorded. So at this stage, we have rejected your bail application.
Wait for your time, Lords.
You'll get the order in the afternoon. I have not yet signed.
My Lords, I'll wait, Lords.
That is why I made it very specifically that at this stage.
My Lords.
None.
My lord, before my learned friend starts, my lord, I think, my lord, there is standing council of forest department, my lord. Actually, my lord, we have been served copy, my lord, but they are probably, my lord, forest department should appear, my lord, in this.
The forest department is already there, lordship, post list, in post list, name is showing.
Can you inform Dixit?
Yes, my lord, I'll inform, my lord.
Take it after some time.
After some time, my lord.
Always.
About. No, no, pick up my-
11.
Thank you.
আমি হেঁটে গেছি নিহতে
And the last two orders dated 30/08/2024 and 07/08/2024. Ulta korte, 07/08/24 and 30/08/2024. It was already observed that the petitioner took back the brief from the learned council. SAB Kabir. However, fielded and how thereafter petitioner did not appear in the matter. Either engaging new counsel or writing so. Hard. Mr. K. Vishal and additional public prosecutor for the respondent state. And state respondent number 1 and Mr. A. Kapata, A.S. Kapata, learned counsel for the respondent number 2. We'll give another opportunity. List on.
This time only my respectful prayer will be for a short date, my lord.
This month only will be good. 23rd.
Deeply obliged.
Your lordship. So, senior advocate Mr. J. Kama will appear in this matter, your lordship. It only will maybe taken after some time, your lordship.
Lordship, I pray for fixing a date in this matter, my lord, because my senior is on legs before coordinate bench, my lord. That matter will take some time, my lord. So, any date, any date?
On the prayer of the council for the parties. place this matter on when
Lordship, after vacation, my lord, any date now?
after answering on a date to be fixed by the agency on after answering to the vacation. Till the next date of listing of the matter. Interim order passed earlier. In criminal revision petition number 345 of 2022. Shall remain.
Okay, there is an interim order, Your Lordship.
That we have made it.
Obliged.
Wait, please, your lordship. Lordship, the engaged senior counsel is out of station, lordship. Lordship, may I please to fix the matter on Friday, lordship.
Yes, what do you have to say?
My lord,
Next week.
not on Friday, my lord.
Commencing from 23rd?
23rd, my lord.
25th
25th.
on reply of the council for the parties list.
Not on 25th, my lord, 23rd or 24th, any day, my lord. 25th, I have matter in a CBI court, my lord.
27. Till then.
Lordship, interim is there in all the.
Oblige you.
Obliged.
I'll give you the-
May I please, Your Lordship? Lordship, I think maybe adjourn for the timing, Your Lordship. My senior is lagging, code number 10, Your Lordship.
Yes.
Yes, my lord.
Anachula.
My lord, this petition has been prepared for quashing of criminal proceeding. Otherwise,
Why should it be quashed?
Lordship, the SARS cognizance has been taken under section 498A IPC, Lordship. And for taking cognizance under 498A, Lordship, there should be a valid marriage, Lordship. There should be relation between them should be husband and wife, Lordship. They have relied on an marriage agreement, Lordship, which is not such notarized marriage agreement is not permissible under the law, Lordship. And more so, there is nothing on record that marriage was solemnized as per religious rights, Lordship. That's why if the marriage is not valid, Lordship, then the cognizance under 498A cannot be taken, Lordship. And prosecution under 498A cannot be continued. I have annexed some judgments of different high courts, Lordship, in respect of this marriage registered by notaries and Lordship and conviction or charge under 498A, Lordship, in case of invalid marriages, Lordship.
Yes, Mr. Razat, what do you have to say? Apparently, the particular document that has been annexed is on the basis of a agreement to marry.
Lordship, that is agreement to marry.
Agreement to marry. Was there any valid marriage?
Lordship, that whether there was a marriage or not, that is a Lordship that has to be decided during trial, and that is a disputed question because they have disputed. And other thing, if you Lordship see the FIR page 23, the first 3 lines made it clear that he has the false promise of marriage is there. And the accused kept her as a wife for 8 years. And that itself, Lordship, sufficient to attract section 493 and 376, Lordship, read with section 90 of IPC. So whether those things are there or not, that can be decided only after a trial.
The victim is more than 40 years old.
That is there. And because their
But
relationship
even if it
is for 8
at
years.
the time of incident, she was a marriage, she was a major.
Major. Because Lordship may kindly see that they were residing together, staying together. That in the FIR itself, first your Lordship will see. বিনীত নিবেদন এই যে আজিৰ পৰা প্ৰায় 8 বছৰ ধৰি মোক 6 মাইল কুৰিপাৰাৰ নিবাসী স্বয়ংস বিয়া পাতিম বুলি মোক প্ৰলোভন দেখুৱাই তেওঁৰ ঘৰত মোক লৈ পতি পত্নী হিচাপে ৰাখে। So whether 493 will come, whether 376 will come, or Lordship 498A, that can be decided only after a trial, Lordship. And they have not filed any discharge application disputing those marriage, Lordship. And already PW1 is examining the present case. They have never filed that discharge application disputing those things. And Lordship may kindly see the judgment which is relied on by my learned friend, Lordship. That is regarding, Lordship, not attracted against, those are not related to Muslim marriage, Lordship. Those are relating to Hindu Marriage Act. And those things are whether Muslim marriage is, Lordship, that is a civil contract. Whether those things are there, it is not discussed, Lordship. And the second two judgment which my learned friend has relied, Lordship, that page 57, those are after conviction. After conviction, those were challenged, and that from the materials, from the record, it was decided. And here in the case, they have challenged the criminal proceeding at the initial stage. Those trial is not over yet. So those from page 57 and the other judgment at page 64 are not applicable in the present case, Lordship. And in fact, Lordship, if your Lordship see page 64, they are also the Honorable Court from the allowed the application only because of the paragraph 5, because High Court had declared the marriage to be null and void, and on that ground that 498A was set aside. And in our case, it is not decided yet. First, that has to be decided, which can be decided from the facts of the case, Lordship. And your Lordship is aware that charges can be altered at any stage before judgment. And if it is found that 376 or 493, that can be altered. And that will be sent to the competent court, Lordship. Only because, Lordship, that court has framed Lordship wrong charges, therefore that, Lordship, entire criminal proceeding may not be quashed. Because otherwise she will be prejudiced to lead her case, Lordship. If they have anything, they can dispute through cross-examination or by adducing evidence, Lordship. And in 482 application, Lordship, the disputed question of fact cannot be adjudicated. That your Lordship judgment is also there. Okay. So now it is disputed question of fact, whether marriage is solemnized or not.
Yes, Mr. Amit.
Lordship,
Continue your reply.
their allegation is specifically in respect of 498A, Lordship, and cases registered only on under section 498A, and charge sheet also submitted under 498A. Then cognizance taken, Lordship, 498A, Lordship. And for the purpose of attracting 498A, there should be a valid marriage, Lordship. Nothing on in the FIR or charge sheet, nothing on record, Lordship, that marriage was solemnized as per religious rights, Lordship. They are mainly, Lordship, relying on this marriage agreement, which is not permissible under the law. Agreement is part of the record, Lordship. We have annexed this after obtaining certified copy from the land court below, Lordship. Page 43. And this marriage agreement is also not identified by any advocate, Lordship. And on the basis of this agreement, Lordship, this criminal prosecution may not Lordship continue, Lordship. Cognizance already taken under 498A, Lordship. Merely harassment, Lordship. No more section is added, Lordship. And FIR itself said that promise to marry. Promise to marry, Lordship. Nothing mentioned here that the marriage was solemnized, Lordship. জুয়া সহিংস তারিখে মহামান্য আদালতের যোগেদি কোর্ট ম্যারেজ করি বিবাহ আবদ্ধ হও দ্যাট মাস লর্ডশিপ পেজ 23 লর্ডশিপ ভার্নাকুলার লর্ডশিপ only relying on this notary agreement, Lordship, which is not permissible.
482, in my humble submission, Lordship, 482 jurisdiction can be exercised when no offense is made out. Here it is not a case of no offense is made out. Here, Lordship, they are saying that the charges which is framed, that offense is not made out.
Lordship,
In that aspect, Lordship, only my submission is that whether no offense is made out, only in that case only 482 can be exercised. Because the 482, that jurisdiction is limited. That by taking the entire allegation has to be taken into to be true, Lordship. And if entire allegation is taken into truth, then Lordship, that his intention not to marry me, that is there. And if that is there in view of section 90, that consent given under misconception, that will amount to 376, Lordship. Okay.
Mr. Rahman, please come to the marriage agreement.
Lordship. Lordship.
Page number 43, paragraph 2.
Lordship.
So,
Lordship, agreement,
and going to the FIR, there is nothing wrong.
Lordship, next page, paragraph 7 is also there, Lordship.
No, we have seen that.
Lordship. Lordship.
In that case, what will happen?
Otherwise,
Paragraph
this,
2 is very specific.
Lordship, otherwise this agreement is not permissible. under
Living
the
as a
law.
husband and wife, that's an admitted position.
Lordship, this, they are relying on this agreement, Lordship, this is not permissible under
That's what I
the
was asking
Lordship.
you.
Lordship.
When both both the petitioner and the respondent live together as a husband and wife, 498 will not come.
There should be a valid marriage. That is my humble submission, Lordship. That
Okay.
this agreement
We'll
can
look into it.
Lordship. There should be a valid, legally valid marriage, Lordship. Yeah. In respect to Lordship, I may submit three more judgments in respect of 498 for valid marriage, Lordship. 40. Cheryl, keep it neat.
Paragraph Mr. M.K. Hussain, Council Appearing. You are not there.
Lordship.
Council
His name.
Appearing. And Mr. A.K. Bishop, Additional Public Secretary appearing for the state. Also heard Mr. A. Amit and Council for the project party number. That's Mr. A.K. 38. On 38.
Interim was there, Lordship.
A. Ahmed, Lordship. Lordship, A. Ahmed, that for info. A. Ahmed, Lordship.
Yes, yes, we have done that.
Okay.
Yes.
In the last occasion, asked me to bring the appeal memo. Appeal filed by them before the learned session judge.
What is the state?
No, that is over. That was disposed of, and the learned session sent back the remanded back the matter. Set aside the order and remanded back the matter. That I in the IA I have annexed, Lordship. Page 78 of the IA. And they have been directed to give the assets and liabilities. Now they have given the assets and liabilities, and the matter is fixed for necessary orders after hearing the matter.
Take your seats. Okay. Mr. M. Gabriel, I counsel for the petition. And Mr. T. Bussell, and additional public prosecutor, deputy for the state respondent. Also heard Mr. T. Talukar, not counsel for the respondent. Number 2, slash. By this application and the second part, the petitioner has prayed for quashing of the proceeding of domestic violence case number 76 M. 2018, initiated by the petitioner. Sorry, initiated by the respondent person against him under the provision of the Protection of Women from Domestic Violence Act. Setting that the respond number and setting that the criminal case under section 490 of the IPC, being their case number 12759 of the against the petitioner. It was initiated at the instance of the respondent. Decided in favor of the petitioner by the London Judicial Magistrate First Class from Rupert by judgment dated 17/06/2019. As the prosecution failed to prove the charge in the section 490 Act against the petitioner, and accordingly the London Trial Magistrate repeated him of the said case. The case number is 521 of 2001. The petitioner also submitted that he has already divorced the respondent number 2, and such divorce was registered in the office of Muslim marriage of the opposite register, Guwahati, Masudar Party, Abu Basam, Guwahati, and a certificate that record was issued. Or petitioner admitted the response number 2 and the meanwhile filed an application under section 7 of the small read with explanation with the small b of section 7 of the Family Court Act in 1984. Read with section 34 of the specific delegate act. Praying for a declaration that the degree of divorce that is Indian citizenship is executed by the petitioner is bad in law and consequent in civil case number 8250 presently pending deputy court of Honorable Family Matter. It is further contended by the petitioner that the response number 2 earlier filed an application under section 125 for granting maintenance being FC within the criminal case number 2100016. In May 2016, before the principal judge family court at Guwahati, and that pursuant to the order of the family court, he is paying rupees 13,000 as enhanced maintenance per month to the It is also submitted by the petition that earlier petitioner filed ATV case number 104M 2016 against the petitioner. Seeking interim relief or granted magistrate by order 0603/2017 did not pass any such order for interim relief of the petitioner in CTP case number 104M of 2016 and later as the respondent number 2 withdrew the same DB case number substantive. Now, magistrate disposed of the same by order dispose of say DB case number 10 and of 2016 by order. submitted by the petitioner that the present review proceeding being 76 M of letter being filed in June 2015 by the respondent is only to harass the petitioner as he is living separately from the petitioner since February 2016. The intention causing harassment and demanding more money from him. Petitioner also stated that the said DB case number 76 in 2018 next fixed in the stage of filing of assets and liabilities by the party. And if the said DB proceeding prepared by the petitioner against prepared by the respondent of the petitioner out and additional maintenance directed to pay has been paid for amounting to rupees 13,000. The said respondent himself have to pay an additional part and thereby separated. Hence this criminal action for by the petitioner for pausing the proceeding of certification. By filing its affidavit, the respondent number 2 brought to the notice of the court that earlier on 18/12/2020, the Learned Sub-Divisional Judicial Magistrate in Bracket 1, Kamrup Metro, allowed the said DB case number 76 M of the 2018 after hearing the respondent number 2 in which the petitioner did not appear and remained absent without any steps. And the learned magistrate by the said order dated 18/12/2020 was directed to pay rupees 5,000 per month to the agreed woman respondent number 2 as monthly interim maintenance from the date of the order till the disposal of this or till further. And also directed the petitioner to provide a suitable residential accommodation to the respondent number 2 and to pay rupees 5,000 per month as rent. Mr. Talabdul and council for the respondent to submit. Next. In the said order, the date such and such, the learned magistrate also direct the petitioner prohibiting public restraining him from committing public repeating the acts of domestic violence, both physical and mental torture of the verbal, emotional abuse. On the aggrieved person, respond number two. Not to alienate the assets of the respond number two slash aggrieved person, which are in his custody. And further, directed the officer in charge of Bhattigaon Police Station for issuance of search warrant so as to search the premises of the petitioner for the articles mentioned in the application submitted by every person relating to say the case number 76 and 15. Observing further that in the event of recovery of the articles has been stated by the aggrieved in our application that are not disputed by the respondent by the petitioner, the same shall be handed over to the aggrieved person slash respondent two on her executing a bond of 1,00. Mr. Talubdul, counsel for the respondent number two submitted against the said order of the learned subdivisional judicial magistrate one from dated 18/12/2020, case number 76 and 2018. The petitioner preferred an appeal, being criminal appeal number 8/2021 before the court of learned session and the learned additional session judge number 1 Kamrup Metropolitan by order the 23/02/2023. First in said criminal appeal number 8/2021. Partly allowed the said appeal of the petitioner and remanded the matter to the court of learned. Setting aside the said order of the magistrate dated 18/12/2023 relating to the monetary receipts only, enabling the magistrate concerned to pass a threshold in respect of the interim maintenance of the interim monetary relief AFRES after considering all aspects and on receipt of the affidavits on disclosure of assets and liability, directing the trial magistrate to pass a thought on interim maintenance affairs as per law, without being influenced by any observation made by the said appellate court while disposing of the said. Mr. Toledo, the counsel for the respondent number 2 pointed out that the petitioner suppressed the said decision of the learned trial magistrate dated 18/12/2020, passed in DB case number 76 and 2008, as well as the order dated 23/02/2023, passed by learned additional session that number 1 from 8 in criminal appeal number 8/2021, that was preferred by the present petitioner. On perusal of this criminal petition, it is found that the petitioner is totally silent with regard to the filing of the said criminal appeal number 8/2021 against the order of the learned trial magistrate dated 18/12/2020, passed in DB case number 76. Nikhil. Pursuant to the order of the court dated 02/09/2024, Mr. Talodal and counsel appearing for the respondent placed a certified copy of the criminal appeal number 8/2021 referred by the appellant, i.e. the petitioner hearing before the session judge, district and session judge come. Against the said order of the Honorable Magistrate. It is seen from the said memo of appeal being criminal appeal number 8 of it. Its appellant, i.e. the petitioner, raised all the issues has been mentioned in this criminal. After hearing the petitioner as well as the response number 2 against the said memo of appeal, the response number 2 also filed her objection. After hearing both the petitioner as well as response number 2, an additional session that Kamrup Metro Party while remanding the matter to the learned trial magistrate, I, as reserve number 1, for fresh consideration of interim maintenance, amount of interim, after receipt of the affidavits on disclosure of assets and liability. In the said judgment dated such and such, specifically observe that the appellate court did not find anything to interfere with the order of interim reliefs granted to the present respondent number 2, the affidavit. This aspect of the matter has been suppressed by the petitioner in this case. Considering this criminal petition stands dismissed with a cost of ₹25,000 to be paid by the petitioner, out of which the petitioner shall deposit an amount of ₹15,000 before the learned subdivisional judicial magistrate number Kamrup Metro 1, Kamrup Metro Guwahati, in DV case number 76 M 2018, on or before 30th of September, and on such deposit 15% that shall be released in favor of the agreed person, that's one number 2, by the learned magistrate. Further, the petitioner shall pay ₹10,000 to the District Legal Services Authority Kamrup Metro Guwahati. On or before 30. 0920 26 2024. And shall obtain a written receipt in that regard from the Secretary DL as a Kamrup. And shall place it before the land as the number 1. And the taking is not. The certified copy of the memo of criminal appeal number 8/2021 that was filed by the petitioner with the Court of Land District and placed by Mr. Peter Locker, Council Appeal. Be kept as a part.
Mansum.
Number 10. You will be appearing for the forest?
No, Lordship, I am appearing for the veterinary department, Lordship. Respondent number 3, Lordship. Point.
For the respondent number 3.
3, Lordship. We have already filed our affidavit, Lordship.
So you said forest department?
Mr. Gogoi was informed, by Mr. R.J. Board was informed me.
Let him be there, we'll take it after some, as soon as available.
May I please your lordship? My lord, here is the case petitioner is a retired principal, who retired from service on 31/1/2021. After retirement, he got GIS, DCRG, lecture, etc., and getting pension. But GPF money was not paid. But after filing of this petition, I got the GPF money, and 1 month salary still remain unpaid, lordship. And midday amount, lordships, I utilize my money as per instructions by SMDC. The midday money that has also not been paid. Last time my friend stayed, made submission, he got the instruction and take time to file an affidavit, but no affidavit we received, lordship.
My lord, today I'm appearing on behalf of respondent number 4, my lord, B. Gogoi, my lord. We have sent our affidavit for vetting, my lord. I'm praying for 1 week time, my lord.
Earlier, as per instruction, salary 1 month has already been sanctioned, lordship. They sent to the SG, lordship. That direction may be given, lordship. My salary, lordship, retirement. That may be paid as midday meal. Maybe.
You are appearing for whom?
Headmaster. And Malada, for the president of the concern, my lord. Allah, I made a submission that I will take care of actually, Malada, I will go only for festival.
You are representing the principal, respondent number 7.
7. And I will my it is wrongly written 8 also.
Okay. Yes, what is your instruction? How much amount to be given? 1 month salary, so
1 month
insufficient?
salary, lordship. 90,000 something. 90,490.
The amount. It doesn't have the 90,000 amount. What is that insufficient budget total? What kind of instruction have been furnished to you? It can provide 1 month salary to this teacher, who is a retired teacher. Well,
midday meal is concerned, my lord.
Mr. Ahmed, just tell us, the respondent number 7 is the DDO. Now, he has submitted a bill before the treasury.
No. Before the IS to send to the court.
To the government.
Because earlier his bill was left. Because he has not received the salary.
Salary for which particular month?
January 2021, lordship.
January 2021. So as a DDO, you have prepared the bill and
My lord,
forward.
earlier he was the principal.
We
He
understood
himself
that
prepared.
amount was left.
Left.
Now-
But no, my lord. Then when the bill was gone to the treasury, he refused to accept it because some short was there. 13,000, he prepared excess bill. So he says, so that is, that's why his bill has been left. After we,
You rectified the mistake.
the mistake done by them.
Now,
Yes, now they rectify the mistake, we have.
earlier, the petitioner, while he was a DDO, has made an enhanced inflated bill, right? Exceeding 13,000. Now, after you being the DDO, what you have done?
Yes, so we'll, correct bill we have.
You have sent the correct bill. Now, yes, the IAS, the inspector of schools, this is from Nalbari district, right? Have forwarded it to whom? To the director. Now, what director is doing? For a, that cannot be, get the instruction. Ask the DSC to say that for a, the state is that DSC cannot pay a salary for a month to this particular person. Get the instruction when it will be paid.
Subsequent fault of respondent number 9 losses, my learned friend appearing, he did not submit the bill. That's why complaints made before
Mr.
the IAS.
Barodia,
Lordship.
you have heard the, you know the judgments, right?
Yes.
The Honorable Apex Court, while considering all these aspects, have also considered one aspect, that the person concerned should not be a DDO.
Yes.
If DDO makes that mistake, he will be responsible for that.
Normally, we are now going to rectify because huge amount is to be returned.
Have you recovered?
It will be.
How will you recover it?
There,
He will recover it. From where?
from his salary. From
Why? There
From
is no
where?
order at all. Where from
From
recovery?
additional, my lord, he is doing excess salary.
Where is that? Where my learned friend says, I do not know losses.
And
Now,
but this midday meal amount is contract absolutely false, my lord. No permission has been given to by the SMC. No resolution has been passed in this respect. School has authority not asked him to give me loan, my lord. He said he give the loan.
Audit report
this
reflected.
90,492, how much it has come now? 88,172. You have already released the GPF amount. You have
Yes,
received.
in the meantime, after filing of this deed petition, I bought it.
You have received 9,30,000.
Yes.
What loan amount you had? What loan amount? you
Loan
had?
amount, lordship, 2,52,019.
What purpose?
Midday meal, because sometimes the authority did not sanction the money and there is a
Then don't
direction
feed the
not to.
children. If the
not to
government is
give.
not giving sanctioning any amount, don't feed the children. That's all.
And that's why authority, assembly, school manager requested me to provide some and the audit report reflected lordships that has been taken. That is page lordships 38. May I kindly be looked into in the audit report, it has been reflected. Page 38. Next page, lordship will got bottom lordship loan from principal in course of checking the general fund and MDM fund cash book. The following amounts are offered as loan by the
Whether this
principal.
audit report has been accepted.
Oh, my lord, page 39, last part. It was also noticed that above transactions were made without the approval of the assembly.
As the audit
We
page,
know nothing. Assembly know nothing.
it is revealed rupees so outstanding balance still which may be refunded to the principal subject to approval of the
This
assembly.
has no value.
Yeah.
Right? This is the finding of the audit.
So lordship, that amount I am entitled, that is
How you are entered?
lordship, it was also
The last
looked
paragraph is
into
39.
some money has been, it was also noticed that the above transactions were made without the approval of the assembly. As such, audits failed to ascertain the genuineness of transactions from the above. Yes, next lordship, it is revealed rupees 3,24,242 is outstanding balance till 31/3/2021, which may be refunded to the principal. The next line, lordship.
This 3,24,000 for what purpose?
That I provide, I utilize my money in the
For
midday
what?
for the purpose of midday meal. There is an instruction, lordships.
Okay. So as ISS directed you to release it from your fund or the SMC?
No, there is a direction from the director also, lordship. It should be continued. Sometimes received lately, and thereafter some money has been paid to me in the audit report. It has also been reflected. I got some money, 38,181 got also.
Yes, SSA.
My lord. SSA
What
received instruction regarding
We have
midday
received
meal
our
also.
instructions, my lord.
What is your instruction?
My lord, para 10, my lord.
Give it to me. When did you retire?
I retired already, lordship.
On which
On
date?
31/1/2021.
Heard. Mr. M. Borpian, sorry, F.U. Borpian, Learned Counsel appearing for the petition. NMS. Urban Week. Learned Standing Counsel, Secondary Education Department for the response number 123. You are Mr.
H. Burwa, my lord.
Also heard Mr. H. Burwal and additional Standing Counsel SSA for the response number 4. Who is appearing for AG?
KK Mehdi on behalf of Mr. S.K. Mehdi.
Committee and council for the AG Assam Accountant General. Response number 6. And Mr. Dey Ahmed, Grant Council for the response number 7.
Seven, right.
Principal 3 million higher secondary. Who is appearing for 9? You are appearing for 9? 9 is the same person.
Same person, 7 and 9, same person.
7 and 9. Petitioner is directed to take step on the response number 8 by registered postal service. Providing its correct and postal.
Service completed, lordship, as per earlier.
Wait, I cannot appear 8.
Mr. Ahmed, they are council appearing for response number 7 and 9. Committee doesn't have the authority to appear on behalf of School Management and Development Committee for the multi-million higher secondary school represented by its president. Next, in view of the above, the petitioner is directed to take steps on response number 8 by raise the post. One of the 4. 11. providing its correction for the Next, in addition to the above, petitioner is also allowed to take steps on the response number 8 by the stable personnel service to be routed to the density of this. The stay of the personnel service on the response number 8 is the having a copy of this petition along with the annex in presence of one or more witnesses, getting necessary acknowledgement from the president of the present president of the SMDC of Mukti Mukalmo, the statement. And thereafter petitioner shall file an affidavit. Thus completion of the stay of the persons. During the deliberation of the matter, Mr. Bormia, counsel for the petitioner, submitted that he has already received an amount of rupees 9,30,893 towards the GPF. When did you receive that?
Date actually the
GPF amount.
GPF amount received after filing of this date petition also.
Entire amount 9,30,000.
Yes, entire amount lordship.
Full and
That may be very lordship, maybe more or
because GPF money to his full and final after filing this. And he is yet to receive which month salary?
January 2021 lordships.
Yet to receive the area salary for the month of January 2021, amounting to receive rupees 90,49. About amount only. We have full and final. Mr. Bormio also submitted that he has not yet been paid the loan amount of rupees 2,52,019 paid by him towards midday meal of the school during his tenure for a period in which the government, state government, did not release the fund. In this regard, Mr. Purwal and his counsel appearing for the SSS summit that he shall file an affidavit in the matter within a period of 2 weeks. Within a period of 2 weeks for the respondent number 4. Mr. Ahmed, London Council, appearing for the respondent number 7 and 9 submitted that earlier petitioner submitted an inflated, being a DDO during his tenure, submitted an inflated bill amount for the monthly salary of January 2021 amounting to rupees 90,492. And the corrected amount, though the concerned treasury officer paid to the petitioner, he did not receive the said amount. And accordingly, it got lapsed. Thereafter, the present principal in charge of the school calculated the monthly salary of the petitioner for January 2021 at rupees 88,172 and forwarded the same to the inspector of schools in Northbury, who in turn forwarded the same to the director of secondary education. Release that amount by November 30th. the respondent authorities in the secondary education department, including the DSC Assam, Inspector of Schools Nalbari, shall release the correct amount of monthly arrear salary of the petitioner for the month of January 2021 in his account as per his entitlement on or before 30/11/2024. If not paid, if not already paid, if not paid already. Place this matter again on 23rd of October.
Lordship, regarding service of notice, there is a Dosti mood also. I submitted affidavit also, Lordship. They received.
File fresh.
By Dosti service, they received, Lordship.
Mr. Borwe,
Lordship, I obliged,
Don't
Lordship.
take court's time.
I'm obliged.
Individual, respondent number 6/4. Yes, sir. Mr. Borwe, you are opening for 4, right?
Respondent 4.
Shall file its affidavit in terms of on or before. (2509). Serving a copy of the counsel for the petitioner and after respondent. Thereafter, petitioner shall file his reply, if any, to such affidavit of the respondent number 4 on or before 3rd of October.
Lordship. Obliged.
Hey, Burwa.
My lord.
Yes.
This matter, my lord, the petitioner has to satisfy this court that the proceedings which are going on against him, my lords, are liable to be quashed. The parameters has to be set up by him, and he has to satisfy this court.
Yes.
Because the offense complaint is of a forest offense. And one thing I have to admit that when he was in office, the work started before it. Whatever destruction of the forest land without permission, it started before he entered in his office. And another angle may be explored, my lords. The petitioner is a retired person now. That's all, my lord. Otherwise, it's up to him how he satisfies, my lord.
Lordship, complaint is that petitioners has constructed a veterinary complex in forest land, Lordship. That is the allegation, Lordship. But this
Yes, yes.
Yes, Lordship. From the complaint itself, it is evident that the construction was started in the year 2014. But the petitioner number 1 was the retired director of veterinary department, Lordship. And petitioner number 2 was the executive engineer, assistant executive engineer of PWD building division, Lordship. Lordship, if your Lordship come to page number 45, Lordship, of my petition, Lordship. This is regarding the petition number 1. In the interest of public service, Dr. Kulin Chandra Das, Deputy Director, Khanapara, Guwahati 22, is hereby allowed to take over the charge of in-charge Director, Animal and Husbandry Veterinary Department, Lordship. So he took office only from 31st of July 2018, Lordship. And next page, Lordship, 46. This is regarding petitioner number 2. This is to certify that as per record available in this office, there is no any outstanding liability against M.A. Barbuya, Assistant Executive Engineer, Guwahati Building Division, during his incumbency period as Assistant Executive Engineer under the division with effect from 1/3/2016 to 16/10/2019, Lordships. So he was in that division from 1/3/2016 to 16/10/2019, Lordship. The construction was started in the year 2014 itself, Lordship. People, Lordship, come to the complaint, Lordship, at page number 36.
Yes.
On verification of record available in the office of the Range Forest Officer, Kurua Range, Bagora, it reveals that Animal and Husbandry Department, Dr. P.C. Das, Director, with the help of Assistant Executive Engineer, M.A. Borbia, started construction work of the veterinary hospital complex inside the Kurua Hill Reserve Forest from the year 2014. They did not came to that office, Lordship, in the year 2014. These works, they have started by the predecessor of the petitioners, they have started the construction works, Lordship. And the predecessors also, Lordship, before starting the construction work, they have visited the site, Lordship, and the circle officer of the concerned area, Lordship, he has given permission to construct that area in the year 2014, Lordship. That, Lordship, Lordship, will get at page number 52, Lordship. I have given a type copy. This is not legible. Let me read the page number 52, Lordship. With reference to the subject cited above, I have the honor to inform you today, that is 2nd August 2014, the undersigned made a joint visit in connection of the construction of veterinary hospital complex at Kurua, accompanied by the Assistant Executive Engineer, PWD Building Division, Mongoloi, and Circle Officer, Sipazai, Revenue Circle, are in opinion to state building as veterinary hospital complex Kurua. It is for your kind information that the land is yet to be registered in favor of Animal and Husbandry Veterinary Department. Although the land is being occupied since long time, from where veterinary activities are being performed from the existing hospital, the circle officer is agreed to get a register of land DAG number 50, area 6 Pika 4 Kota 12 Plesa, village Borua Sapori, in favor of the veterinary department. So from it was previously using as veterinary hospital, Lordship. In that land, one veterinary hospital was going on. And though it was not registered in the Animal and Husbandry Veterinary Department, Lordship, even that the circle officer has given permission to construct in that area. And
Where you
because
are
of
reading?
Lordship,
Where you are reading?
page number 52, Lordship.
52.
52, Lordship. Lordship, thereafter, when this anomalies has occurred, there was a committee formed, and that committee was directed to verify whether that area falls under Forest Department or it was under Revenue Department, Lordship. That is at page number 64 of my petition, Lordship. In the interest of public service, Government of Assam is pleased to constitute a committee with the following officials to conduct an on-the-spot verification of the plot of land of the State Veterinary Dispensary Kura, Dorong, and whether the land belongs to the Forest Department or Revenue Department. These were the incumbents. Thereafter, a verification was also conducted and report was submitted at page number 66, Lordship. Last part, Lordship, findings. The present plot of land where the Kurua State Veterinary Dispensary Complex, including the newly constructed dispensary building, is situated belongs to Forest Department, and the land which was allocated to Kurua State Veterinary Dispensary measuring so and so, covered by DAG number so and so, is situated in a different location adjacent to the dispensary building inside the public road. Hence, a proposal for deforestation of the said forest land is to be submitted before the competent authority of Forest Department, Government of India, situated at Shillong after completion of necessary formalities. Further, it appears that the skeleton structure of the dispensary building and quarter, including the concrete roof, have been completed. Lordship, thereafter, Lordship, a file was also moved. Lordship, next page, Lordship, page number 67, Lordship. Minutes of the meeting regarding construction of veterinary hospital at Kurwa, Lordship. The meeting discussed the progress of construction of veterinary hospital complex at Kurwa under RIDF and also the developments arising out of the objection raised by the Forest and Environment Department on the construction site. After a thread-based discussion, the following decisions were arrived. As Executive Engineer Division has requested to make second point, Lordship, further in respect of deforestation of Dag number so and so, where the dispensary has been constructed, a file which number so and so has already been moved to the Environment Forest Department. It is decided to approach the Environment and Forest Department for obtaining concurrence in regard to the same again. Thereafter, Lordship, page number 69, Lordship. Second point, Lordship. The Chief Conservator of Forest so has informed the House that a case was registered against concerned authorities of Animal Husbandry, Veterinary Department and PW Department by DFO NK Division, Rongia, White Forest offense or report number so and so, dated so and so. This case would be withdrawn after receipt of clearance from the competent authority under FC Act. So they have only furthered the construction which was done by the predecessor of their office, Lordship. They are not liable for any punishment under the Forest Regulation Act, under the alleged offense, Lordship. So they have already retired after discharging their service. So, Lordship, at this stage, and Lordship, what happened? In this case, their complaint case, Lordship, the earlier judicial magistrate who was conducting the complaint case, Lordship, she committed some irregularity in conducting the case, Lordship. So the subsequent judicial magistrate who took over the office, Lordship, after finding out that irregularities, Lordship, as page number 42 of my petition, they referred the case to the session judge to see the irregularities. And session page number 42. The case number so and so is fixed for evidence today. The case is filed under section so and so. I have minorly perused the case record. Upon perusal, it has been observed that the instant case is a case which is instituted other than on police report under section 244 to section 247 of CRPC. In the instant case, the accused person had appeared in the case and were granted court bail subsequently. The case was then fixed for consideration of charge by my learned predecessor in office on 2/4/2022. Subsequently, charge was framed and the matter was fixed for evidence. However, it came to my observation that the matter should have been fixed for evidence before charge, but it had been fixed inadvertently for consideration of charge. And thereafter, the evidence of two witnesses were already recorded. Therefore, in such circumstances, in the instant case, in my opinion, will not reach its desired conclusion as per the provision of law, and thereby I deem it fit to forward the case to the Honorable District and Session Judge Dorong, Mongoldoy for kind perusal and necessary action. Thereafter, Lordship, Session Judge's opinion at page number 44, Lordship. Case record of so and so is received from the Court of Learned Judicial Magistrate First Class Dorong as per the order dated so and so. Upon perusal of the case record, it reveals that the matter should have been fixed for evidence before charge after the appearance of the accused person instead of consideration of charge, which prima facie reveals that the order passed in CR case number so and so suffer incorrectness, illegality, and impropriety. Hence, in exercise of power and jurisdiction conferred under section so and so, CRPC, I deem it proper and expedient to examine the scrutinize the orders passed in this case. Registered a criminal revision case in this regard. Issue notice both the parties. Office is to do the needful. The case record of so and so is kept with the instant record. So there are two cases now going on. One is
for the correction of the order, right?
Yes,
because the order should have been for evidence before charge.
ABC, Lordship, yes.
But before that it has been made CC,
CC,
consideration of charge. That's
Yes,
why.
Lord.
And in the meantime, evidence of two particular witnesses have been recorded.
Yes, Lord.
That is the different issue altogether.
Lordship,
Now just tell us one thing.
Lordship,
Please come to page 36.
36, Lord.
Read just the first paragraph.
First paragraph. On verification of draft.
Oh.
Available in the office of the Range Forest Officer Kurua Pagora reveals that Animal and Husbandry Department PC Das Director with the help of Assistant Executive Engineer M.A. Barbia started construction work of veterinary hospital complex inside the Kurua Hill Reserve Forest from the year 2014 without authority and without obtaining any permission from the central as well as state government. In this connection, the Range Officer Mr. Ranjan Gaura issued a letter number so and so to the District Veterinary Officer Circle Officer about this construction. Write his letter number so and so. After completion of 50% of work, copy of the letter so and so again during the last year month of August 4th, 2019, restarted the works, and hence on 19 August 2019, the beat officer has issued a letter to the contractor Sri Gunaram Kakoti, Guwahati file letter number so and so, to stop the work. Exhibit after receiving the letter, the contractor concerned suspended the work. Dr. P.C. Das, Director of Animal and Husbandry Department, Assam Senugati, has issued a letter to the DC Dorong Mongoldoy, wherein it was stated that an area of measuring so and so under DAG number 50 was allotted to them for construction of veterinary hospital complex. Height Circle Officer Sipaza Revenue Circle, file letter number so and so, dated so and so. On joint verification, it was finalized that the construction work was done inside the Kurua Revenue Forest. Their reserve forest, though the forested land was provided to the veterinary department for construction of building, but without taking prior permission, they have constructed the building inside the reserve forest. It is nothing but intentional negligence and clear violation of FC Act 90, and hence they have committed an offense under so and so, liable to punish under the provision.
So this indicates what? That after the issuance of letter on by the Forest Department on 27th of December 2014, the work after completion of 50% construction of this hospital, veterinary hospital, was stopped because it is inside the reserve forest land. Why again in the month of August 2019 during the tenure of the petitioners?
Because this
Why it was restarted?
Lordship, because this was this scheme came under RIDF scheme, and
Whatever
that was
with the scheme, we are not on the scheme. It was brought to the notice of the authority in the veterinary department that it's a reserve forest land. And that's why the construction was stalled. Right? But why in August? Because this matter cropped up because till the completion of 50%, thereafter the letter was received that it is a forest land, that also reserve forest. Why without the obtaining any such clearance? Why it was restarted in August 2019?
Lordship, actually, the letter was sent in the year 2015, Lordship. They had taken
So
office.
veterinary department was aware of the fact that the land in which this veterinary hospital has been under construction is a reserve forest land, right?
That
it was already communicated. The work was stopped. And suddenly during the tenure of the petitioners, why it has been started in August 2019? Under what authority?
That they might have, Lordship, missed because
Might have or might have, we do not know. It's a reserve forest.
reserve
The
forest
law will be the same.
in the year 2018 and 2016 only they have came, Lordship, to the office, Lordship.
See, basically, that is why we're asking you. Why during the tenure of the petitioner it was restarted? It was already closed. It was stopped. Why in August 2019 it was restarted?
Because that RIDF scheme, it was to be over by September
That
2019.
doesn't mean that it will go on an illegal construction.
Because Lordship, page number 45, if your Lordship ever come to page number 45,
No, we are there.
in the year 2018 only he became the.
That doesn't matter. The work was stopped. It was restarted during your tenure. Why? When the land, there is no clearance. Wrongly,
from the
Mr. Counsel, wrongly it might have been proceeded with.
Lordship, from the,
Wrongly, it might have been proceeded with, but once the forest department has made it clear that it's a reserve forest land, without the clearance, the construction cannot go on. It was stopped. Then why during your tenure, it was suddenly restarted? Your argument is that the amount is going to be lapsed.
Lordship.
And you finish the amount.
No, Lordship,
Where is that authority?
second,
To go ahead with this particular construction, where was your authority? When did you receive the clearance from the forest department?
forest clearance has not been received, Lordship.
Then why did you progress with the construction?
Because already
That
there,
money would not have lapsed. That money would have been in revenue received or somewhere it deposited. Why you have finished that amount? There the streamline is there. The line,
Lordship,
it is there.
the area is hilly area, Lordship. It is full
We are
of,
not on that. It's a reserve forest, right?
Lordship.
It was a reserve forest. Wrongly, the construction was started inside the reserve forest. Forest department has intimated to you. The work was stopped. Right? During your tenure, why you have restarted it?
It was not known to them, Lordship.
How can it be possible? Why you have stopped it? Is indicated, the forest department prior to that has indicated to you, thereafter the work was stopped. That is why the court asked you to read the first paragraph. The entire complaint. Tell us.
Lordship,
Tell us.
Lordship,
Why you have started, under what authority, when you have been intimated that's a reserve forest land?
it was it was done unknowingly, Lordship.
It was started, it was stopped, but it was intimated that it's a reserve forest. Possible, then maybe because since there was no such demarcation, possible, maybe wrong.
Yes,
That is, the construction was started wrongly. We are not on that. The work was stopped immediately when it was intimated that it's a reserve forest. Why you have started it?
That is
only because the amount is going to be lapsed.
Lapsed, and also that
That cannot be a ground.
they were not aware.
Since the amount was going to be lapsed, you will continue with the illegality.
Not illegal. They were not known, Lordship. They were not
How
aware.
can it be not known? The forest department has intimated to you, the veterinary department.
When
the
the
work was stalled.
when the forest department intimated, Lordship, that
That is
time
clear,
this,
it is letter is here.
these petitioners were not in the office, Lordship.
See, when did you join at 2018? You were in office. You started in 2019 that construction. How can you say you are not aware of that?
No, that forest department information, Lordship, that was sent in the year
You should have inquired why the work was stopped.
This-
Then you would have come to know.
They
Anything else?
They have already retired.
Anything else?
Lordship, then let me get this instruction on this point, Lordship.
No further instruction is required. You have started your case.
I have started, Lordship. They have already retired. They have rendered
That
the
doesn't matter.
service.
You have retired or not. We are not on that.
Lordship,
You might have retired, but you have done during your tenure of service, right?
Lordship, they
That
have,
cannot be a ground.
Lordship, they have not done any such heinous stuff. They have only
They have done. That amount was going to be lapsed. They have done that. That is the issue.
that will be an
Nothing-
assumption, Lordship, only. They have already rendered their services, Lordship, without any blemish, Lordship.
Maybe.
And that will be
That
just
cannot
an
be a ground.
assumption, Lordship, that because
That cannot be a ground.
that that amount is going to be lapsed, and because of
You are
the
representing Ms. Kotoke, representing veterinary. Why you have made a particular veterinary hospital in a hill? You want all the animals to climb up the hill. It reveals from the circle officer's note that it's in a public road. It reveals from the note of the circle officer that it is in a public road.
government has also taken a decision to withdraw this case, Lordship.
They have not withdrawn.
Still not, Lordship. They have already retired, Lordship. For this, they should not suffer, Lordship. There is a letter from the executive, assistant executive engineer, Lordship, to the executive engineer. There are certain points, Lordship, at page number.
Read para 2 of that letter. Read para 2 of that letter.
The work was started on the proposed site along with the contractor and concerned JE on 2/7/2014. The site is toe line of hill full of plenty of tree bird, heavy jungle with big size rock. This site is located in an isolated place. During execution of the work, the progress of the work was very slow. Requested the accelerate the pace of the work with the interest of completion of the work time and again, but the contractor failed to achieve the target. Finally, a notice in
Read the paragraph 2. What was the condition of the land?
condition was hilly area.
Then what were there?
It was there. It was a veterinary hospital was there earlier itself, Lordship.
Kindly read para 2 of that letter at page 47.
Yes, Lordship. The work was started on the proposed site along with the contractor of concerned JE on 2/7/2014. The site is toe line of hill full of planted teak tree, bird, heavy jungle with big size rock. This site is located in an isolated place.
Then come to page number 48. Read the 6th paragraph.
Therefore, the forest range officer requesting to stop further work in the above mentioned site until the matter is resolved, or if any objection certificate has been received from the Department of Environment, Forest, data so and so, dated so and so, from the forest range officer, Kurua Range, Bhagavan.
So, in August 2019, there was a specific letter.
Thereafter, it was stopped, Lordship. After getting this letter, Lordship, it was stopped. Thereafter, it was not progress, Lordship. Through this letter only, these petitioners have come to know, Lordship.
Yes, Mr. Gogoi.
I have very limited submission, but things are very crystal clear. It's a forest land and it's a violation of one central act and one state act. That's the very fact that earlier there was a hospital or dispensary, whatever structure, not reflected here anyway. There are a lot of minute appended to the petition.
It is.
Communications are there. But it is correctly pointed out, it was a full big hill with a big rock, and it was an isolated. That's all. Otherwise, I leave it to
No, that clearly indicates that there was no hospital in that area at all.
It is. I am just showing, Lordship. It is there from 1985. It was going on, Lordship. Lordship, at page number 62, Lordship. Page number 62, Lordship, paragraph number 2. It is worthwhile to mention that the land measuring so and so was certified to be land of Animal Husbandry and Veterinary Department, file letter number so and so of Circle Officer Sipazar and the veterinary hospital is established in the said land in the year 1985 and is in operation since then.
Land was allotted to you when?
Before,
year?
in the year 2014, Lordship, before starting the construction, Lordship.
When
So-
the land was allotted to you? Where is the allotment order?
Allotment order I do not have. Lordship.
Okay, we'll pass the order.
Lordship, kind of consider they have already retired, Lordship.
Maybe. So. And the ground.
And their predecessor only started the construction, Lordship.
You look into
And,
that.
and because they have already appeared, and after that, the criminal division case also registered, Lordship. At this age, Lordship, at Mongoldoy, Lordship.
We cannot say this it. We'll apply our judicious and then we will see.
Okay.
That's all. Mr. Gogoi, when did you for the first time inform the forest department? When did you veterinary department?
Take 2014. Take the page. First paragraph.
Show us from records that it was served on the veterinary.
I have to get the offense. I'll bring.
Show us from there.
I'll bring.
When?
Next week.
24th.
24.
24th. List on 24th. Just a minute. Burua. Show us that this letter was served on the veterinary department. That's the record. Show us that it was served.
2016. 26 to 57.
Give it to us, give it to us. It's in the, show us that it was served.
Well, I'll. I'll bring the record.
List on 24th, and I'm bringing Mr. D. Gogoi, standing counsel for his department. Place the relevant documents to establish the fact that communication number KR public 17 public RF public 2014-15 public 285-288 dated 27/12/2014, issued by the range officer. Range officer of which range? Purua range. Bah, Gaurav. That's it. Wrong. It should be under Kamrup or wrong?
This is, I division where this matter,
Was duly served.
this Corpeta matter, division is Corpeta, forest division. This district is now.
The Assistant Veterinary Sir, Department of Veterinary Animal Science, Husbandry, Chipak. As reflected. In Annex 1. Offense report.
Let's see. Lordship, till then the interim of the published.
Yes, ma'am.
May I please your lordship, the petitioner before your lordship is working as mother teacher under Baksa district, my lord. And their salary has been area salary and current salary is not paid. This is the third time litigation by the petitioner, my lord. And last occasion, Mr. B. Chaudhary, BTC.
Who is appearing? For whom? You are appearing for BTC. So you are paying. This is for ADR amount.
Area and current also, petitioner is still working, my lord. Only 500 remuneration per month. After filing of the first writ petition, there is an order by this court that is.
When did you join?
I have joined in the year of 1997, my lord.
Any idea when these advertisements were made? Any idea when these advertisements were made?
I have no idea, my lord.
Now, for getting any such salary from the public exchequer, there has to be an advertisement. Whether the petitioner mentioned in the petition when these posts were advertised?
No.
These are all provincial high school, right?
Yes, my lord.
So there has to be an advertisement. When these advertisements were made?
I have to take instruction, my lord.
Find out, because if advertisements are made and you have been appointed, you will definitely get it. Question of regularization is a different issue altogether.
Yes, madam, but there is a salary.
For such engagement, there has to be an advertisement, whether for a fixed pay or something like that. That's the law. Public
I think
exchequer
it's
has to
what
be
you
paid
do.
only after following the provisions of Article 14 and 16.
That the petitioner earlier approached before this court, my lord, that is an NHI pays.
That is not the issue you're asking, but that's why when you
after that,
post your
they
advertisement.
have received some amount of money, 36,000. Some amount of money they received in the 2015. Thereafter, they again file another petition where this court has directed to pay the arrear salary. But
Arrear salary straight away or in accordance with law? Can you show us that odd judgment where straight away it has been asked to pay arrear salary or in accordance with law?
Page 72, my lord, paragraph 7. Lordship, I am reading. This court in the earlier round of litigation is culminated in the order dated 10/4/2012. This passed in 8/64/2009 had come to a categorical finding that the engagement of the members of the petitioner association as mother teacher are not in dispute. And in fact, the BTC authority had admitted to such a claim regarding engagement. So their engagement is not a disputed fact, my lord.
Has to be on the basis of the policy laid down under the Article 14 and 16. That's why we're asking you, where is the advertisement?
Sir, review has been referred considering the same and also taking into consideration that the case of the petitioner has been thought to be educated with certain order incumbent who are praying for regularization of their services. This court is of the opinion that the case for interference in the exercise of power under Article 2 to 6 of the Constitution of India is made out. Accordingly, orders impugn in these writ petitions dated 15 July 2016 and 18 July 2000, by which the claim of the petitioner.
See, any matters relate to the payment of public exchequer, right? It has to be, salary has to be paid from the public exchequer. And particularly with regard to the service, there has to be an advertisement, maybe for fixed amount or maybe for regular salary. Unless there is an advertisement, if some authorities goes on admitting the fact that somebody has been appointed, how it can be considered?
But petitioner.
You are aware in numbers of cases, it is the law but laid down by the apex court that it has to be.
File affidavit, my lord, then.
Show us the advertisement by which these persons were filled up on such fixed pay. File your affidavit. List of the 3 weeks only to be picked for registry. Enabling the petition has to open. The authority concerned publish the advertisement for appointment of mother teacher in the BTC area and fixed remuneration. Moreover, the respondent in the BTC shall file its affidavit on or before (23/09/2024), serving a copy of the same in the counsel for the petitioner as well as other respondents. As notice in this case was issued way back on 6/11/2023. List accordingly. Yes, ma'am.
Your lordship, my lord, this matter may be listed again, my lord, next week, my lord. Because I received a call from the petitioner, my lord. He is supposed to furnish some additional documents, my lord.
On the prayer of
Support
MS
of his
SB
case.
Chaudhary, counsel for the petitioner, matter is adjourned for 2 weeks. This is a legitimate.
May please only, it is a matter of 482 regarding quashing of the petition. Your lordship, as per order dated 17/7/2024, I filed the additional affidavit.
When?
I would take copy to the respondent. Page 59, 61, 62, 64.
Yes.
Your Lordship,
Mr.
there are
Sharma.
so many decisions.
Mr. Sharma,
Regarding the washing matter, I also submit here with the latest decision of the Apex Court.
which one?
Yeah.
Paramjit Batra,
Naresh Kumar.
Naresh Kumar.
Naresh Kumar.
Latest decision.
Okay. What is the finding?
Your Lordship, I rely on the para 6, 7, 8.
There are 6, 7, 8.
Para 6, 7. No. 6, 6, 7, 8. The 6. 6, 6.
Yes.
In case of the Paranjati
That we have seen.
versus
Then
your Lordship.
Number 4.
Number 4. Having heard the learned counsel of the both parties, we are of the considered view that the finding of the High Court on this aspect are not correct. We do not agree with the finding arrived by the High Court for two reasons. Firstly, the dispute between the party is primarily civil in nature. It is, after all, a question of how many bicycles the complainant had assembled, and the dispute between the parties is only regarding the figure of the bicycle. Consequently, the amount liable to be paid. This is civil dispute. The civil suit. The complainant has not.
just so that the same amount was claimed in the commercial suit by the respondent.
Respondent. So
commercial suit. You have received the summon, right?
Yes, my lord.
Where is the
Your Lordship,
claim in the commercial suit?
No, your Lordship, order pass this court, pass order 10/6/24, para number 7, the 37,000.
Which page? Which page?
Amount actually dispute regarding the 1 crore 10 lakhs 49,230. Now payable the amount. Now payable amount 37 lakhs 445.
Mr. Sharma, do you deny that there is a commercial suit pending with regard to the same issue?
No, there is a one commercial suit is also pending.
With regard to the same involvement, same issue?
Involvement, but my first.
We can understand your humbleness, but thing is this, are you using a different kind of force to take out that amount by filing a criminal case?
Lordship, they have treated, they have represented themselves to be a partnership firm, and thereafter ran away from Guwahati to the south. Our case is totally different there, the criminal case. And in the commercial suit, Lordship, for the realization of money. Moreover, Lordship, there is no such power under the provision of the law that if the criminal case is filed, then the civil case cannot be filed. There is no such bar under that. Even they have admitted in their petition also.
Please come to page number 49 or whatever. Come to page number 47. What is the address given? What is the address given?
Address is Lordship, NS 37 Khetri Kamrup Metro.
Then
Now they are noted. Now they are.
read completely. Read completely. Read completely. What is the address, registration office?
Registration office is Lordship. The Sindhi Colony, first cross JC Road. Bangalore, Karnataka. Lordship. But no, after taking the book, they ran away from here. In the year 2020, January, they have purchased the book. So thereafter,
What is the delivery?
Lordship, material embodied here. That page 47, it's the material inward. Next for PC Trading Company. That is the material inward.
Okay.
Decision will be done.
Payment only one lakh after investment, I ask you that is when not every established intention is something or that from beginning. Beginning 18 years
Permission. Time to show us now. In the listed for hearing, will you not small government. It is.
Yes, Mr. Talukdar.
My lord,
You have received the goods, not paid.
not
Why?
due to financial crisis, out of most of the amount paid. But Your Honor, may I like a period order this code, this record 10/6 to 2024. There is a 37 lakhs 98,445. The remaining due to their financial crisis, most of the amount paid. As per the Naresh Kumar's husband, there is a specific
Page number 5.
page number 5. No, we admitted they filed the case, criminal case, wrongfully.
The complaint has
Not- Complainant has not been able to establish that the intention of the seat, the complainant was there with the appellant rights from the beginning, merely. গতিকে we are due to financial crisis, they cannot be paid. Most of the amount paid.
The complaint has to prove that there's a cheating from the beginning.
What is the ground for quashing of the proceeding? Why it should be quashed?
It is a matter of civil nature. Commercial suit means civil nature dispute. There are other decisions also. This is the latest.
The commercial suit initiated by the respondent.
Respondent.
What is the amount?
This amount, 37 lakhs.
Where is that?
That is 37 lakhs.
Where from you are showing?
90.
Basically, it's
Which page?
Commercial. Page 64. nahi?
Realization there.
Page 64. nahi?
Page 64.
Page 64.
Page 64.
Petition issue.
They a suit against you for the realization 64 lakhs 57,000 356. Including perhaps it may be interest. 64. Actually that amount.
Complaint petition, if there are 33%, 1,54,000 of the also payment to ইমানৰ লোকে বাকি খিনি হেৰি কৰিছে চিটিং কেনেকৈ চিটিং একোৱে নিদিলে হয়
Sitting is not coming.
Mr. Talukdar,
Your Honor.
get this copy of the suit, commercial suit, certified copy. We want to see whether this 37,000 is included or not.
Let us put.
From Guwahati, you can have it. Obtain the certified copy of the suit. We consider.
No, we are not getting the claim.
You can obtain the certified copy of the suit.
Your Lordship, make a, kindly fix it one then.
Okay.
I shall produce that.
Twenty-fifth.
Master.
25th. List on 25/09/2024, allowing the petitioners to place the certified copy of the commercial suit number 180/2023 pending against him before the learned civil judge, senior division, assistant session judge number 1, matter. The interim order passed earlier on 8/8/2024 shall remain in force. Okay.
Master.
Some complaints from the court, some other also disposed of. So
some time may be granted to file everything. Both the I'm waiting for response about to both the
This issue was already decided, I believe.
Yes.
It was decided. What else you want?
Though it was decided, but it is this specific case not it is different. Because it is always we have also filed two civil suit before the civil judge. And in that cases we have got a decree from the court.
So how this criminal petition should not be allowed?
This criminal petition is a defamation filed by the complainant.
That is why. That's why you're saying the issue has been decided already. Then
But
should you-
already we have got decree in civil suit.
civil suit was for what?
The petitioner himself is also one of the party in that. And in Supreme Court, it is well settled principle of law that criminal courts are binded by the civil.
Yes, Mr. Sharma, what do you have to say?
My lord, the civil case is talking about, I'm not aware, my lord. Second thing is that this is a criminal case, my lord. The approach, because vicarious liability, concept of vicariously is in civil case, there may be. But in criminal case, there cannot be a concept of vicarious liability. And there are plethora of judgments, your lordship is well aware, from apex court to our own high court. And where in all of the cases, your lordship, the CMD has been discharged or allegation against the CMD has been quashed. Plethora of judgments when there is no specific allegation. And the entire complaint case they have brought, I have annexed that also. There is not a single whisper directly or indirectly against the CMD of a news channel. So, Lord, my humble submission, this is a clear case, my lord, where there is clear judgments. And I'm not aware of what he's talking about the civil case, but even though, assuming that that is there, but even though the setup of criminal case is totally different, lordship, parameters are different and compensation is different, and here they are seeking the jail of a person on the basis of vicarious liability.
In one case, they are liable to pay damages on the same issue. Why not punishment on that same? The Supreme Court is very much clear in that case. Well established principle of law that decisions of the civil court are binding on the criminal.
And prepare the counsel for the complainant. Matter is adjourned till 25th. 2024, election 25th.
Well, interim order passed.
Interim order passed, I believe. Has no.
I have submitted an additional affidavit with obtained certified copies, lordship.
Last occasion, my lord, the report that was called for. The purpose that my lord was asked for.
The report was submitted.
Yes, ma'am. Otherwise,
Whether these materials are produced before the court. Mr. Boyso, as for the division bench judgment, you have to clarify first.
they have always said they don't have the objection. That part was there.
That is there.
Yes.
Whether it has been produced before the court. Once the matter has been produced before the court, it cannot be released right away.
Yes, ma'am.
Let us know about that. Just a minute. When did you approach the IO for Jimma of the vehicle? Any idea? When did you approach? Where is your ownership? Which document to prove that?
I have no.
Which document to prove that you are the registered owner of the vehicle? If you have applied for the on the Vahan app, you will have a number. Where is that? Me too. $24 quid. $44. These are all.
Director has to get the draft.
Let's say item number 48, very important, my lord.
Yes, I was thinking that.
Very kindly.
Same process. Already government has given the approval, only the appointment order is required to be issued. Can it be the content will still wrong?
Mr. Das, probably this bench will take up bench to matters coming 2 days. So automatically these matters will come. These are all education matters.
I agree with the law that we are working for the foundation. Can it be on Monday, Lord? Time zero. Otherwise,
These are all education matters, you know. So it can take up any day. Kalipur bench to teacher. Twelve.
My date, my lordship. 48.
48 is a criminal matter.
43, my lord, there is a interim order. My lord, item number 35, there is an also interim order, my lord.
Give the item numbers where there is the interim.
48, my lordship.
Give the item number.